So there is really so much concern in the current economic environment of companies or even parastatals having either to retrench personnel or indeed go the route of shutting down. So if a company does close and if it goes into liquidation, where does that leave you, both the employer and the employees? So to give us a little bit more insight, we're joined in studio by Tebogo Choane, who is the Labour Relations Manager at Legal Aid South Africa. Good to have you. Thanks so much for coming in.
Good morning, Leah, and thank you very much for having us.
Let's use Ndalo Media, because I suppose that's a very high-profile case. It's currently in the news right now. We're all looking at this. Let's use it as an example. They closed in December last year, and former employees have just been told that the company has gone into liquidation. My first starting point is, talk to me about liquidation. What does that actually mean?
In simple terms, Leanne, liquidation is a process where an employer, in a situation like Ndalo, who is experiencing financial difficulties, is in a situation where their liabilities exceed their assets. In other words, they are unable to fulfill their debts with their creditors.
Okay.
So in that instance, they approach a high court, which is the only court that they can approach with an application for liquidation. It can be an application done voluntarily by the employer or by the creditors.
Yeah. Where now does that leave the employee and the employer? Let's start with the employer, the rights of the employer when you are liquidated. What is the route that you go there? Then we'll move on to the employee.
The employer has various rights, Leanne. They have a choice to go the dismissal based on operational requirements in terms of Section 189 of the Labour Relations Act, read with Section 189A of the Labour Relations Act, but that route is usually not so preferred by the employers.
Absolutely.
Especially in the circumstances Ndalo Media finds itself, and therefore they would go for liquidation. Now, the rights of the employer, insofar as liquidation is concerned, is to simply make an application for winding up of the company. If it is, for example, an individual or a sole proprietorship business where one person runs the business, it is sequestration. So the employer has a right to approach the court and apply, and the court will then entertain that application. It will not dismiss it outright because there is some interrogation that has to take place in terms of the Insolvency Act.
Yeah. So now we get to the employee, because again, I use Ndalo Media as an example, and we keep using it as an example, but this is not an isolated case. This happens all the time. The employees are furious at the moment over the delay in the payment of their severances packages, of their benefits. They've approached the Commission of Conciliation, Mediation and Arbitration when they learned that the company would be liquidated. And you know, there's a lot of concern there. So what are the rights? Should this be taking this long? This is from December last year. Let's just put that down.
Yes, Leanne. Unfortunately, legal processes usually take longer than people would like the process to take. That's as a starting point. And secondly, the liquidation, for as far as the employees' rights are concerned, has got a unique feature in the sense that the Insolvency Act takes application other than the Labour Relations Act, and the rights of the employees are suspended in terms of the Insolvency Act, which means if an employer approaches the High Court, in this case in Ndalo Media, for liquidation, in terms of Section 38 of the Insolvency Act, the contracts of employment that the employees have with Ndalo Media are suspended until the final order as to liquidation is granted by the court. The court may also grant a provisional liquidation order. And the rights of the employees insofar as the benefits are concerned, including salaries, including pensions that you mentioned,
that's what I want to touch on as well,
are also suspended insofar as the contributions are concerned.
So that's actually what happens. Even though in this instance, Old Mutual is who holds the pension funds, they can't comment, but what they did say was that Old Mutual takes the non-payment of contributions by employers very seriously and are distressed by the delay this causes on members being able to access their benefits. So I suppose that's a generic statement that they've just released, saying that we'd love to see them being paid. But what you're saying is that everything is frozen until the High Court decides. So there's nothing that you as an employee can do.
There is literally nothing that you as an employee can do until the application for sequestration or liquidation has been granted as a final order. But employees have various recourse.
Okay, let's get there, because this is sounding desperate for an employee right now.
Yes, you mentioned earlier on that the employees have already approached the CCMA, and employees have a right to do so. But the CCMA, unfortunately, in terms of the law, does not have jurisdiction to entertain disputes over the validity of a liquidation application or that process of itself. The High Court has, but the CCMA can entertain disputes about severance packages. But Leanne, at the end of the day, employees still sit with the problems, because even if there is an agreement on how much should be paid out as severance pay, which is usually 1 week for every 1 year of continuous service with the same employer, the law says, and particularly the Insolvency Act says, that even if there is an agreement, the liquidation process and order dictates that the creditors will have to be paid first. But creditors include employees, and employees' salaries take preference in terms of the law. So there is a certain ranking in terms of the Insolvency Act, in terms of which employees will be entitled to certain things. But their rights in terms of the Act is that, one, unfortunately, employees will only be paid their salaries once the debts have been paid.
So, but as you say, the ranking, where does that put employees? Are they at the top, or is it first creditors? Even though they're seen as creditors, but where do the employees fall into the ranking?
You could say in the line of order, the employees unfortunately fall second, because there is what is called secured creditors. There is what is called preferred creditors, and the employees fall under that category. And there's also what is called concurrent creditors. But if I have to give you an example, if you allow me.
Please,
in terms of the Insolvency Act, if employee A, in terms of the Insolvency Act, earns 6,000, for example, per month, and the employee B earns 4,000, employee C earns 2,000, they may not necessarily get the entire amount. Employee A, who earns 6,000, will be able to only get a maximum of 12,000 rand. So for the last 3 months, which means 3 months before the sequestration or the liquidation. In other words, 6 times 3 is 18. The employee will not get 18,000. They will get a maximum of 12,000, because that's what the Insolvency Act says. The employee who earns 4,000 will get 12,000, because 4 times 12 times 3 is 12. The employee who gets 2,000, obviously, per month, they are not paid too much. It will be only 6,000. However, the employees will be who, for example, the employees who earns 18,000 will only recover the difference as a concurrent creditor. Once there is a freeze residue that does not have or is not encumbered, I hope you understand, which means it's not subject to securities.
Sure. I needed to take notes on that one. I did. I hope the viewers got that, and they got all the figures. But the reality is that it sounds to me like the employee comes off second best here, and there's very little recourse for them, if in fact there isn't enough funds available to even pay them out. Do you get to a situation like that once the other people have been paid and you are standing there waiting in line, and by the time they get to you, the funds have run out. What happens then?
Unfortunately, it is possible, but the employer has a responsibility to make sure that they apply for liquidation as soon as they realize they have a financial situation.
Yeah.
So there is an investigation that the court does into whether or not you needed to apply for liquidation. Otherwise, the court can also say, we're going to give you a judicial management order wherein management is given back to the employer to manage the affairs.
And as it stands right now, I mean, when you hear from a lot of the employees, they don't have the money to take this any further, and their hands are basically tied, and they have to just sit and wait this out with no income and no money coming their way at all. I suppose what I need to ask you is, what is the most amicable way to resolve this, and to move forward and just walk away from it?
Employers are supposed to be very transparent with their employees.
And that's a point that a lot of the employees are saying, is that they're not being transparent here.
Yes, they are supposed to be transparent, and in any way, the law dictates that at some stage, the employer, Ndalo Media, will have to consult with the employees before even the final sequestration is granted, because they have to look at ways with the employees or the trade union that represents them, if they are represented, if not personally, to see how they can rescue the organization, part or wholly, and including whether the transfer of the business can take place. So basically, that's what happens. But look, even if the employees have referred a matter to the CCMA, at the end of the day, the CCMA will give a ruling that severance pay of so much that was agreed must be paid. But the question is, once the final order is granted and the debts are being paid, will the employer be able to see to the severance packages that were agreed upon? So in terms of various aspects of law, including the law of contract, those issues become rather secondary if you look at the Insolvency Act.
All right, we have to leave it there. Tebogo, thank you very much for talking to us. Tebogo Choane is the Labour Relations Manager at Legal Aid South Africa, trying to shed a little bit of light on workers' rights during a company's liquidation process. So I hope that's helped you if you are in fact going through something like that. Right, the time is 8 o'clock. Let's get into our top news bulletin.